Hello and welcome back at Ease No Media, where we discuss media related topics at ease. Happy Independence Day to you all. Today we will be talking about the landmark cases of law of our unit, that is the media law. Today we will be discussing about the landmark cases of media law. So first thing first, what it has been given. Number one, Ramesh Thapar versus State of Madras. The first judgment case was Ramesh Thapar versus the State of Madras. So as you can see, it's the violation of freedom of speech and expression. It talks about the violation of freedom of speech and expression, isn't it? So the journal named Crossroads Freedom of Circulation, it came from the journal named Crossroad, where it is written the freedom of press and circulation. Now what we will be discussing about this particular cases. We will be discussing about this particular cases and the importance of the case. We will be also covering the importance of the case, so that what will happen, we will be having a in-depth analysis. In this in-depth analysis, we will be first trying to understand about this particular cases, the importance, why importance in media law, why media students must know this particular cases, right? So first thing first, the as we have discussed about the Ramesh Thapar case. So if we talk about Ramesh Thapar versus State of Madras, it was back in 1950. So what was the issue about? The issue was a ban imposed under section 91A 19A of the Madras Maintenance of Public Order Act in 1949, prohibiting the circulation of journal Crossroads, argued to violate Article 19(1)A, freedom of speech and expression. The Supreme Court struck down the ban, emphasizing that freedom of circulation is an indispensable element of freedom of speech. They are saying that it's the indispensable element of what? Indispensable element of freedom of speech, and that public safety alone did not qualify as a reasonable ground for restriction under Article 19(2), which initially did not include public order. Now we must be knowing what signifies this case, why we are studying this till now, because as far as the significance is concerned, affirmed freedom of press as integral to freedom of expression in a democratic society. It established doctrine of severability, allowing for striking down unconstitutional proportions of laws without widening the entire status. Now it sparked the political response, led to the first constitutional amendment in 1951. So this case is very important, not only from the point of view of media, but it is the first amendment, constitutional amendment, about the adding the ground like public order, the incitement to offense as reasonable restriction, and undoubtedly it became a touchstone in Indian constitutional jurisdiction, cited in later cases related to the press freedom and digital expression, right? Now the next case, the next landmark case what we will be studying is the Brijbhushan versus State of Delhi. Same thing, it was also in 1950. So what was the issue? It was under section 71C of the East Punjab Public Safety Act. Alright, the Chief Commissioner of Delhi directed the weekly organizer to submit pre-publication copies. That means what they will be publishing, they have to submit the pre-publication copies of all communal news and views about Pakistan for scrutiny, a form of prior censorship. So this was the Brijbhushan. It was also known as Brijbhushan Sharma versus the State of Delhi. The ruling, the Supreme Court struck this order down, right? After striking this order down, holding that prior restraint on publications is a serious encroachment on the freedom of press, which remains protected under Article 19(1)A. reinforce that pre-censorship is unconstitutional unless justified by a clear, intimate threat to public order. Alongside Ramesh Thapar, it marked a dual affirmation of press freedom on the same day by the Supreme Court. So became a foundational case for what? For safeguarding the editorial autonomy and restricting state priority. So now if we consider both the cases, if we consider the Ramesh Thapar versus State of Madras and Brij Bhushan versus State of Delhi, Ramesh Thapar, the ground issue was freedom of circulation. We have to remember this fact. The ground issue was freedom of circulation, Article 19.1a and 19.2. The decision struck down ban on circulation. And the significance why the media students has to learn this, to affirm press freedom doctrine of severability prompted First Amendment. The next thing what it comes, that the prior censorship, if we talk about Brij Bhushan versus State of Delhi, it talks about prior censorship, the pre-publication review. It struck down pre-censorship order, upheld autonomy of press, prior restraint deemed unconstitutional. Now the broader importance in media law, if we talk about the broader importance of media law, what we can see, these cases collectively underscores fundamental constitution principles, isn't it? Obviously, because it underscores the fundamental constitution principle. Press freedom is vital to democracy. Both ruling rejected states overreach into editorial decisions and circulations. Cornerstones on democratic discourses. The restrictions must be narrowly tailored. The court insisted that only clearly enumerated grounds under Article 19 to justify limiting speech. Judiciary as protector of civil liberties. Supreme Court asserted these roles in checking arbitrary executive action via Article 32. It reinforces the judicial review. Why? Because the concepts like prior restraints, severability, and a strict interpretation, right? It was the strict interpretation part of reasonable restrictions. It continue influencing media and speech related litigation today. Now we will be talking about the Virendra versus State of Punjab. If we talk about the Virendra versus State of Punjab, so it was in Punjab. So what happened? Virendra versus State of Punjab, we can see that it happened in 1957. Pre-censorship, unreasonable restriction, same thing, from freedom of circulation. The fact is that this case involved two Delhi newspapers, which we have to understand, which we have to remember. The Pratap, which was in Urdu, and the Veer Arjun, which was in Hindi, published from Jalandhar and simultaneously from New Delhi, under editors or publishers including Virendra and K. Narendra. Their editorial stance supported the Save Hindi agitation amidst rising communal tensions in Punjab over linguistic reorganization. The state government enacted the Punjab Special Power Press Act in 1956. To curb publication it deemed likely to disturb communal harmony and public order. The provisions under challenges, what we can see is the section 2A. It authorized the state of prohibit the publication of any matter related to Save Hindi agitation for a limited time, with the added safeguard of following the aggrieved party to make a representation. Got it? Now if we talk about the constitutional challenges, the petitioners argued that both sections violated Article 19.1a, freedom of speech and expression including freedom of circulation, and Article 19.2, right to carry business publication newspaper. It's in 19.1g. So in 19.1a we have freedom of speech and expression, and in 19.1g we have right to carry on business publishing newspapers. Now Supreme Court's ruling, if we talk about the Supreme Court's ruling, what we will be having, that the section 2.1 upholds the reasonable restriction under Article 19.2. So we have discussed today what? We have discussed today about the Ramesh Thapar and the State of Madras. We have discussed today the Veer Bhushan versus the State of Delhi, and we have discussed the Virendra and State of Punjab. Tomorrow we will have a brief discussion on K.A. Abbas and Union of India. So thank you for connecting at Ease No Media, where we discuss media related topics at ease.